Once the new owner has entered a case against you in court, you will be served with a summons and complaint, which tells you a lot of very important information. First, it tells you what court your case is in at the very top of the page, and what day you need to be in court for your hearing. It also tells you the reason for the new owner's eviction, as well as your deadline to file an answer. Your answer deadline is often located at the bottom of the page, but it appears on different places depending on the form used by your local court. This is the second most important thing to look for after your hearing date. You must file your answer, request for a jury, and request for discovery on or before the answer date listed on the summons and complaint. Your answer is a document which explains all of your arguments to the court. It allows you to make legal arguments and also to tell the court why it's unfair for you to be evicted. Legal Services has developed a form which lists almost every possible argument a tenant could have. You can access this form online at www.masslegalhelp.org. You should seek legal assistance in filling out the form if you can. Find your local legal aid office at masslegalhelp.org and find out if they have a free eviction clinic where they can assist people in filling out their answer, and register for the clinic if you can. Your answer date is also your deadline for asking for a jury trial. If you don't ask for a jury trial by this deadline, you are not entitled to one and your case will be heard by a judge. Juries are sometimes more sympathetic to tenants and former owners, and so it can be helpful to request a jury if you think you might want one. You are able to request a judge trial, sometimes called a bench trial, later if you change your mind. Along with your answer, you should file a request for discovery, which is a set of questions and requests for documents which helps you understand what the other side will present to the court at your trial. Discovery is a critical part of any civil case, and the other side is also allowed to ask you for information and documents, although they often do not. If you don't receive discovery from the other side within 10 days of requesting it, you may file a motion to compel to ask the court to force the other side to produce it, and you have 5 days to file that motion. A sample discovery packet can be found at masslegalhelp.org, and if you get assistance from your local legal aid office with your answer, they will in all likelihood also help you complete this form. If you filed your answer and request for discovery on time, your eviction trial will be postponed for 2 weeks automatically. When you do go to court, on your rescheduled trial date, it's important to insist on complete production of your discovery requests before the court schedules your trial. Otherwise, you will be going into your trial with incomplete information about what the other side will present to the judge or the jury.